I'll be talking about the doctrine of frustration and force majeure in contracts, which is relevant to the Section 56 of the Indian Contract Act. And our teammates are Komal Singh, Nisha Verma, Jevin Bopanna, and Jitesh. So, next, doctrine of frustration and force majeure, Section 56. So, in everyday life, we make agreements or contracts with others. For example, renting a house or supplying goods, organizing an event, or building something. Once the agreement is signed, both the parties are expected to do their part, perform their duties, perform their promises. But if something unexpected happens, like natural disaster, or flood, or earthquake, etc., and government lockdown, like during COVID, a sudden change in law that stops the work. Still, so can the agreement still be carried out? So, this is where the Section 56 of the Indian Contract Act becomes important. In Section 56, there are two main things. That is, if you agree to do something that's impossible from the start, the agreement is not valid. So, for example, promising to bring someone back from the dead, it's impossible. So, the contract does not count. Second, if something becomes impossible after the contract is made, and it's not anyone's fault, then the contract becomes void. That is, it gets cancelled. This is called the doctrine of frustration. Frustration of frustration in contract law means something happened that no one has expected, and now it's not possible to continue the contract. So, in this, we have to note down that neither party caused the problem. The event must be serious, not a small delay. The event make the purpose of the contract impossible to achieve. So, for example, you book a hall for a wedding, but before the date, the government announces a complete lockdown. Since it's not your fault and you can't use the hall anymore, the contract gets cancelled under Section 56 of the Indian Contract Act. This is called the frustration of contract. Next is force majeure, which tells us that a powerful force, something big and beyond human control, like a natural disaster or war, or natural disaster or war. It's a special clause or a sentence that some contracts include to say if something unexpected, like a flood or pandemic happens, we won't be held responsible for delays or cancellation of the contract. This is not directly written in the Section 56, but it is related because both force majeure and Section 56 deals with the situations where doing the promised work becomes impossible. Example, you sign a contract you sign a contract to deliver 100 bags of rice, but a flood destroys the warehouse. If the contract had a force majeure clause, it will protect you from being blamed. So, if even if there is no such clause, Section 56 can still help because delivery has become impossible.
The origin of the doctrine of frustration can be tracked back to the principle of absolute liability forming the basis of contracts in England. It is usually believed by the courts that the parties to a contract must fulfill their obligations in any situation and are absolutely liable for the same. This theory of absolute liability was laid down by the court in the case of Paradine versus Jane, 1647. Another big step was taken by the English courts in the development of the doctrine in the case of Krell versus Henry, 1903. In this case, there was a contract to hire a flag for the coronation of King Edward VII, but the coronation was cancelled. The, the court held that the plaintiff cannot claim the rent because the coronation was cancelled, which was the foundation of the contract, and hence the contract stands frustrated. This case made the doctrine applicable to those contracts where the primary and commercial objects of entering into a contract is destroyed. Over the years, the following factors have been recognized that rendered the performance of contract impossible. The first is subject matter which was destroyed. When the parties to a contract dies or becomes incapable of performing their obligations. Third, outbreak of the war. Fourth, intervention of government which makes the contract illegal or unlawful. The fifth point is change in circumstances, and the last one is delay in the performance of contract where it is barred and limitation.
The Indian Contract Act 1872 ICA, the doctrine of frustration is covered under Section 56. The doctrine of their sections deal with the doctrine of frustrations, which essentially states that the contract becomes void when something occurs after the formation of the contract, which render it impossible to fulfill the contract into something radically different from what was originally contemplated by the parties. This section is important in understanding the legal consequences when unforeseen events make it impossible to fulfill contractual obligations. The concept of force majeure, though not explicitly defined in the ICA, closely intertwines with the doctrine of frustration. Key elements of doctrine of frustration: first is unforeseen events. The events that led to frustration must be unexpected, and neither party should have foreseen or anticipated it when entering into the contract. Contracts are based on the assumption that certain circumstances will remain the same. If an event occurs that no reasonable person could have predicted, and that event drastically changes the nature of the contractual obligation, then doctrine may apply. For example, a sudden natural disaster, earthquake, flood, destroying the subject matter of the contract, outbreak of war, or a pandemic after the contract was formed. Second, impossibility or illegal of performance. The event must make performance of the contract either objectively impossible or illegal under the law. Objectively impossibility, no one can perform the obligation, not just the parties involved. The law changes after the contract is formed, making the agreed action legal. For example, a person dies or becomes physically or mentally incapable of fulfilling a personal contract. No fault of either party. The frustrating event must not have been caused by the act, omissions, or negligence of either party. If a party is responsible for the event, they cannot claim frustration. The doctrine is meant to relieve parties from situations beyond their control, not protect poor planning or misconduct. If a contract fails to deliver goods because they did not order them in time, that's not frustration. Fourth, valid contract. The doctrine only applies where a valid and enforceable contract existed at the time of the frustrating event occurred. If the contract was voidable, illegal, or never properly formed, the doctrine cannot be invoked. Only legal binding agreements with clearly defined terms and obligations are eligible. Fifth, non-performance. The contract must still be partially or fully unperformed when the frustrating events take place. If the contract has already been fully executed, there is nothing left to frustrate. If the event occurs after performance is complete, the doctrine does not apply. Example: a stage actor signs a contract to perform in 10 shows but falls ill after 3. The remaining 7 shows may be discharged under the frustration. But if all 10 shows were completed before the illness, the doctrine is irrelevant.
Good afternoon. My name is Jitesh Kumar Singh. Today, I have make a video presentation about the legal aspects of business, and we are talking about the position of doctrine in India. India law is mostly inspired by common law, and eventually it has inherited two concept of absolute liabilities. So the doctrine of frustration acts as an inspection. In India, the India Contract Act of 1872 deals with the contract and others aspects related to its. The term frustration of contract is not defined any agreement in the act. However, section 56 of the act makes the agreement that is impossible or incapable of being performed while indicating towards doctrine of frustrations. In the doctrine of frustration in India is a key principle under the contract law, acting as an inspection to the rule of absolute liabilities, where a party is bound to perform their contractual obligation regardless of the difficulty of cost. Legal framework. In India, the Indian Contract Act 1872 governs contract. Will it does not explicitly define the term doctrine of frustrations. Second part is the features of the doctrine. Valid contract. First one. For the doctrine to apply, there must be a legally binding and valid contract in place. If no contract exists or the contract was void from the beginning, the question of frustration does not arise. Second point is the inability to perform. There must be an unfulfilled part of the contract. If the contract is already performed of or the obligation is already discharged, frustration is irrelevant. And third part is the unforeseen supervising events. The event causing the impossibility must be something that could not have been anticipated or controlled by the parties. Fourth one is no self-introduced frustrations. The party cannot claim frustration if the impossibility was caused by their own action, negligence, or any other point is to the whole contract. Frustration must affect the entire essence of foundation of the contract, not just a part. Partially difficulty or inconvenience is not enough to invoke the doctrine. Sixth one is the mixed question of law and fact. Whether frustration has occurred depend on the specific facts of the case and how courts making it is a judicial evaluation based on the both legal principles and real world facts. Seventh point is the automation termination. Once frustration is established, the contract is automatically terminated, not just suspended or modified. And last one is the common intention of parties. Will assessing whether frustration has occurred, contracts try to understanding the original intentions of the both parties. Thank you.
Good morning, I'm Javan Bopanna, and today I will be talking about force majeure and doctrine of frustration. A force majeure clause in a contract is a provision that releases parties from their obligations under the agreement if an event beyond their control and that was not foreseeable, such as a natural disaster or war, makes it impossible or impracticable to fulfill the contractual duties. Is essentially a safety net for unexpected circumstances that prevent parties from performing as agreed. Now we'll be talking about the essentials of a force majeure clause. First up, we have the occurrence of an event. There must be an event or circumstance that makes it impossible to perform the contract. Minor difficulties or inconveniences don't qualify the event, must completely obstruct performance. Next, we have inevitability. The event must be inevitable, meaning it could not have been avoided even with reasonable care and planning by the parties. Next up, we have unpredictable or unforeseeable nature. The event must be unpredictable and unforeseeable at the time the contract was formed. If an event was foreseeable, the parties are assumed to have made arrangements for it. No fault of the parties. The situation leading to the invocation of the clause must not be due to the fault or actions of either party. It must result from external uncontrollable event. Fulfillment of precedent conditions. To successfully invoke the force majeure defense, all conditions mentioned in the contract for such a situation must be met. Duty to minimize loss. The party claiming force majeure must take responsible steps to mitigate or minimize the loss suffered by other party. Doctrine of frustration. Section 56 of Indian Contract Act 1872. First up, it says that if an event happens after the formation of the contract that makes the performance impossible or illegal, the contract is automatically void. Next up, it says that parties can rely on the principle of restitution. If one party received any benefit before the contract was frustrated, it must be returned or compensated to the other party. Next, it says that thus frustration acts as a natural protection when it comes to contracts that lack an explicit force majeure clause. Now we'll be talking about the effects or consequence of the doctrine of frustration. Termination of contract. The contract comes to an automatic end without requiring any action by the parties. End of rights and liabilities. The rights and obligations of the parties under the contract cease to exist. Discharge from obligations. Both parties are relieved from further performance of their contractual duties. Compensation of non-performance. If the promisor knew or ought to have known that performance is impossible but still entered into the agreement, he or she must compensate the other party for the non-performance. Then we have the force majeure clause versus doctrine of frustration debate. Force majeure clause is a pre-agreed specific and provides a framework. Doctrine of frustration, on the other hand, is the legal backup that when contracts do not cover unexpected events. Both aim to protect parties from unfair burdens when uncontrollable events prevent performance.
So now I'll be talking about the recent cases which is related to the doctrine of frustration. So the first case is National Agricultural Corporation Marketing Federation of India versus Elementa SA 2020. So NAFED promised a foreign merchant, Elementa SA, to send them lots of groundnuts, means peanuts. But a rule in India said, thou shalt not export without government permission, and the government said no exports this year. So NAFED, though willing, could not keep its peanut promise. Elementa cried foul and took the matter to a foreign court of merchants. A year passed. Then Elementa knocked on the doors of Supreme Court of India, saying, "We want our reward." But the wise court said, NAFED was not at fault. They were bound by the government's orders. Enforcing the foreign award would go against India's public policy. Thus, the peanut promise remained unfulfilled and NAFED was saved from the paying damages, all thanks to the sovereign rules and judicial wisdoms. So, in this case, if a contract cannot be fulfilled due to the government restrictions, even international arbitrations may not override national public policies. So the second case is of R. Narayanan versus Government of Tamil Nadu 2021. So R. Narayanan owned a peaceful piece of land in Tamil Nadu. One day the government of Tamil Nadu said, "We need your land for public project," and took it under a law called the Land Acquisition Act. Years rolled by. The government neither paid Narayanan properly nor started any real work on the land. Narayanan tired of waiting, decided to fight back. He marched to the court and cried, "This land was taken from me, but nothing was done. Give me justice." The wise judges listened and said, "If the government takes land but does not use it or pay fair compensation, the acquisition is unjust and cannot be allowed to stand forever." Thus, the court ordered that the land must be returned to R. Narayanan, teaching everyone that authorities must act fairly and not sleep over citizens' rights. So, in this case, when the government delays using acquired land or fails to compensate properly, the citizens' rights to reclaim it comes alive.